Smithsonian era developments, and our focus today is preemption. That is, what happens, right? Remember the Venn diagram, the overlapping powers? Some powers are exclusively federal, some powers are exclusively state. What happens in that middle shaded area? And the very short answer is, if federal law contradicts state law, federal law trumps. That's called preemption. But it gets more complicated than that, as we've already seen. And we'll see more about that today. For example, what if the federal government has not passed laws in a given area? Is it possible that state laws are nonetheless preempted by the mere fact that the federal government could regulate a certain area? Are there certain subjects that by their nature require national rather than state regulation? And if so, are those subjects removed from the authority of states to regulate, again, even in the absence of federal law to the contrary? So it's all about federalism and federal-state relations. And the context in which the question arises is the same context in which almost everything arises in this period at the beginning, and that is slavery. So Prigg versus Pennsylvania. The Fugitive Slave Clause of Article 4 says, well, just read it. No person held to service or labor in one state under the laws thereof, so a slave, escaping into another, so an escaped slave, shall in consequence of any law or regulation therein, that is in the other state, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. So if a slave escapes into a free state, the fact that that is a free state does not alter, this is the Dred Scott question, does not alter the status of that slave and make them free under the Constitution. Moreover, the state into which the slave has escaped is required to deliver them back to the owner pursuing them. This clause was followed by a statute in 1793, the Fugitive Slave Act. And you have to be careful in this discussion to distinguish between the Fugitive Slave Clause in the Constitution and the Fugitive Slave Act, which is this federal law giving effect to the clause. The fight is over the act, the statute. So the statute says, when a person, and it basically reiterates the constitutional clause, but then gives it a few more details. When a person held to labor in the United States or a territory, on the northwest or south of the river, under the laws that shall escape into any other part of the said state or territory, right, into a free state, the person to whom such labor or service may be due, his agent or attorney. That's going to be important, that agent thing. Is hereby empowered to seize or arrest such fugitive from labor and take him before any judge of the circuit or district court of the United States. So if a slave escapes, the owner is empowered by this law to hire what was called a slave catcher. The slave catcher would travel into the free state area, seize, or the word we would use is kidnap, literally off the street quite often, the escaped slave, take them before a federal judge, say, hey, this guy's a slave, belongs to the person I'm working for, and the judge will say, great, take him away. The problem, of course, is that this contradicts things like state laws against kidnapping. It is against ordinary state criminal law to simply grab someone from the street and forcibly drag them away to somewhere else that they don't want to go. It's also the case that slave catchers quite frequently kidnap free black people. And just to declare the movie 12 Years a Slave is about a free man who was kidnapped by a slave catcher and held as a slave for 12 years before he eventually escaped. So it was quite common it's kidnapping under either circumstances. The system lent itself to acts of kidnapping, abduction and capture of free people and the forcible making into them of slaves. This is not a rare thing. George Washington hired slave catchers to catch a couple of his escaped slaves. So it is not as though this is something that was unknown to the most elevated levels of our society and our historical figures. The northern states objected to this law. And several of them passed laws saying things like, no, you have to come before a state court judge in our state before you can take anybody out of our state on the theory that they're a rightfully recovered slave. Since, of course, these were state courts in free states, they tended to be hostile to these claims. Conversely, the federal courts tended to be very friendly to these claims and go back to what we talked about last time about the packing of the courts with pro-Southern judges. So in 1837, for example, there was a case called the Case of the Colored Woman Matilda. taking place in Ohio. Salmon Chase, this is not the same Chase as the one running around in the 1790s. This is a different guy. And I don't know why his parents named him after a fish. I just don't get that at all. Salmon Chase is riding circuit. He's presiding over a federal court as a justice. And he argues that the Fugitive Slave Act of 1793, the law that we just read, is unconstitutional. Why? And here's where, sort of irony alert. In order to argue against the Fugitive Slave Act, Chase is going to invoke the compact theory. In order to argue in favor of the Fugitive Slave Act, when we get to Prigg, the defenders of that act are going to use the old Federalist national theory, national people theory. So the deployment of these arguments are flipped from where they usually occur. We will again notice an appeal to originalism or something like it, and again, in the context of protecting slavery. And as I said, in the context of dread, it's very difficult to argue that there was not an original understanding of the Constitution that included slavery. It clearly and explicitly does. So if you're arguing in favor of slavery, the institutions protecting slavery, like the Fugitive Slave Act, then it makes perfectly good sense to appeal to the authority of an earlier period, 40 or 50 years earlier, because there's very little question, there's no question, that at that time this was an accepted practice. By contrast, by the 1830s, there are plenty of people in the northern states who think slavery is immoral and illegal under the laws of nations, that is under international law, or is just immoral under basic morals, right? So there's a growing abolitionist movement. So if you want to argue in favor of the practices of holding people as slaves, it makes perfectly good sense to come up with this argument of saying, hey, we the courts are bound by the understanding of 1787. We don't have the authority to change that. So it's not mysterious that this is how this form of interpretation arose. So here's Chase turning the compact theory against the defenders of slavery. What is that clause in the Constitution in regard to fugitives? Now, this is the Fugitive Slave Clause, not the Act. But an article of agreement between the states. Right? It was a compact among the states, this Constitution was. Does this clause confer any power on government or any officer or department of government? Clearly not. Right? The Fugitive Slave Clause says shall be returned. It doesn't say Congress shall have the power, or a federal court, or the federal government shall have the. It's not in Article 1, Section 8. It's not in a list of, or any of the articles that describe the powers of the national government. It just says shall be returned. Right? Principal enumerated powers. Again, Chase is playing all the classic arguments in favor of slave owning against it in this context. The clause then restrains the operation of a state constitution and state laws in a particular class of cases. Ware versus Hilton, supremacy clause. If your state constitution says slavery is outlawed in our state, it doesn't matter. It's preempted, trumped by the U.S. Constitution. The clause has nothing to do with the creation of a form of government. It is in the strictest sense a clause of compact. The parties to the agreement are the states. The general government is not a party to it, nor affected by it. So in the compact theory, right, we imagine the states as separate countries, bound together by a treaty. In that model, think of extradition treaties. We have an extradition treaty, for example, with Mexico. We do. There's actually some issues about that we might get to. I can't recall if it's in this version of the syllabus or not. But we have an extradition treaty with Mexico. What does that mean? It means we've agreed that when the government of Mexico says, hey, you're holding somebody we want to try for a crime, we'll turn them over, and vice versa. Right? It doesn't mean that some external party has power over both of us, both the United States and Mexico. It's just an agreement between the two parties, and the obligation is on the parties. That's what Chase is saying is true of the Constitution and the Fugitive Slave Clause. The Constitution restrains the operation of the state constitutions, the state laws which would enfranchise the fugitive. It binds the states to deliver him up on the claim of the master, and by necessary inference, it obliges them to provide a tribunal before which such claims may be asserted and tried. Right? It's all very well to say, shall be delivered, but you need a mechanism of some kind. Since this is an obligation on the states, it's up to the states to do it. Therefore, state courts are the places to bring these claims. He loses that argument, but I do think it's interesting to see how he turns the compact theory of federalism, the strict enumeration of federal powers, all these classic pro-slavery arguments, he turns them around against the slaveholding interests in this case, and of course, and they lose. The same thing will happen in Prigg versus Pennsylvania in the U.S. Supreme Court in 1842. An opinion by Joseph Story. And remember, Story is the guy who, in Martin versus Hunter's Lessee, wrote the ringing statement of the national people theory, right? We are one national people. The Constitution was not adopted by states. It was adopted by, the guy wrote well. If you don't know, he wrote the most famous commentaries on the Constitution of this period. He's considered one of the great expounders of the meaning of the Constitution in this historical period. And he wrote eloquently about how we're all one nation, et cetera, right? Not when that would get in the way of slavery. So let's take a look at Story's argument. First, by a general law of nations, no nation is bound to recognize the state of slavery as to foreign slaves found within its territorial dominions. Right? If these really are foreign countries, then Ohio has no obligation to recognize a Virginia slave owner's claim to the ownership of a human being. Your status under French law does not impose any obligations that English law is obliged to recognize. But then comes the Constitution. It is manifest from this consideration that if the Constitution had not contained this clause, every non-slaveholding state in the Union would have been at liberty to have declared free all runaway slaves coming within its limits. Right? We'd have a system, we'd have a situation which is exactly what would follow if these really are foreign countries, where if you get across the border into the other country, you're free. But that is obviously not the case. The unacceptability of that situation, of the possibility of slaves getting across the border into Ohio, and to take the example before us, and thereby becoming free and out of the reach of their erstwhile owners, that was so unacceptable to the slaveholding states at the time the Constitution was adopted, that the Constitution would never have been adopted but for the Fugitive Slave Clause. This is that originalism I was talking about. Right? At the time the Constitution was adopted, we know the slaveholding states would not have accepted any version that did not effectively and adequately protect the peculiar institution to which they were so wedded. Therefore, we are obliged now, 60 years later, to read the Constitution in order to effectuate the understanding that was in place at that time. The clause was of the last importance. There's a curious thing about English language. Last importance now means first importance. It was a clause of the last importance to the safety and security of the southern states, and could not have been surrendered by them without endangering their whole property and slaves. But the same point I made last time about Dred. You can't have a national system with slave states and free states in the same system. Taney was not wrong that creates all kinds of contradictions, unless you treat them as actual foreign countries. But the slave states didn't want to do that in this instance. That would have undermined their ability to capture runaways. The other problem, by the way, besides, there were three great concerns for slave owners. Runaways was one. Slave suicides was another. There was a very high rate of suicide. It shouldn't really be all that shocking. And I had a third one in mind, and I've forgotten what I was going to say. Drat. Oh well. Onward. So, what did the Constitution do, given that we are compelled to read it in a way that will effectively protect the interests of slave owners in preserving their property? Under and in virtue of the Constitution, the owner of a slave is clothed with the entire authority in every state of the Union to seize and recapture his slave. Somebody mentioned the rule of law earlier in a conversation I just happened to overhear. This is an exception. This is what Locke called self-help. In the case of recovering slaves, you don't have to call the police or go to the courts. You are empowered to go off and become a private bounty hunter, or a private, whatever is the right word here, and effect the recapture on your own. It's unique. It's the only area in which private citizens are empowered to use violence to assert their property rights. In any other context, you have to go to the police. That's what the police are for. To see whether he can do it, whenever he can do it without any breach of the peace or illegal violence. Right? That's a little bit of snark there. It is illegal violence to kidnap people off the streets. We've just finished saying that state laws about that are overridden. In this sense, this clause of the Constitution may properly be said to execute itself. Okay, what does self-executing mean? If there had been no Fugitive Slave Act, so no statute, what would have been the effect of the clause in the Constitution by itself? And the argument that, for example, Salmon Chase made was, well, the clause in the Constitution doesn't provide a mechanism, doesn't say how this delivery of slaves to their owners is supposed to take place. Therefore, as he says, by inference, you need more. You need a mechanism, you need a description, and he thinks it must be the states because it's a state compact matter. Story, our great high federalist, who now turns out to be a great high, very pro-slavery federalist, that's not a contradiction. Story is taking the position that no, the clause is self-executing, that in the absence of any statute, federal or state, about the delivery of slaves to their owners, any owner is simply free to grab them and then take them to federal court. So it turns on that question of the meaning of the word deliver. What does it mean to deliver the slave? This leads us to a consideration of the other part of the clause. The slave is to be delivered. By whom to be delivered up? In what mode to be delivered up? How, if a refusal take place, is the right of delivery to be enforced? These and many other questions will readily occur upon the slightest attention to the clause. And it is obvious they can receive but one satisfactory answer. They require the aid of legislation. So it would have been self-executing by itself. People would have had the right to go and grab escaped slaves and haul them in front of a federal magistrate and say, I'm taking them back to Georgia or Virginia or wherever the slave catcher comes from. But obviously, lots and lots of practical problems and questions arise, including questions of preemption of state law, so you needed a statute. The natural inference, right? Same thing Salmon Chase said, it was a natural inference, this is a state court. Here's a different natural inference. The natural inference certainly is that the national government is clothed with the approved authority and functions to enforce it. This is McCulloch. This is a broad reading of federal powers on behalf of the parties who up until this point have insisted on narrow readings of federal powers. Remember, if the federal government can build canals, it could emancipate the slaves. Therefore, they must not allow the federal government to have the power to do things like fund canals. But if the federal government does not have the power to ensure the capture and return of escaped slaves, states might interfere with slavery. Therefore, the federal government must have this power. How do you explain these apparently opposite lines of analysis? It's simple. Slavery always wins. And Tanya's not, it has to. Because if it doesn't, the whole system falls apart. So delivery requires a little explanation, a little explication by the enactment of statutes to work it out, and that's what Congress has done. Congress has taken this very view. The result of their deliberations was the Fugitive Slave Act of 1793. Notice 1793, right after the final ratification of the constitutional adoption of the Bill of Rights. This is not some later addition by a different generation. This act may truly be said to cover the whole ground of the Constitution. If this be so, it would seem upon just principles of construction that the legislation of Congress, if constitutional, must supersede all state legislation. In other words, preemption. So all the state laws of places like Ohio that say things like you can't drag someone out of our state without coming before a state judge or with the assistance of the police, or by violence on the streets, or without presenting paperwork to show you have a valid claim. All the kind of laws, the various northern states had various laws requiring slave catchers to go through procedures before they grab somebody and kidnap them. They're all preempted because they contradict the Fugitive Slave Act. And as I said, the justification for all this is McCulloch. The end being required, it has been deemed a just and necessary implication that the means to accomplish it are given also. Or in other words, the power flows as a necessary means to accomplish the end. All right, so far, I don't want to say so far so good. I was about to say that. All I meant is so far so clear. I know a number of people who think Prigg is the single worst and most horrible constitutional decision by the Supreme Court ever. I don't agree, but only because there's a couple of others I think are even worse. It's one of those, weird complaints. This is the worst restaurant in the world. No, it's not. I know an even worse one. Okay. But so far, so clear. There's a remaining question, though. Is Congress's power exclusive? Right? So the Fugitive Slave Act, if it is directly contradicted by the state law, the Fugitive Slave Act, federal law, preempts under the Supremacy Clause. Easy. What about cases where the conflict is not so direct? That is, does this mean states are not allowed to pass any laws about the recovery of escaped slaves and the operations of slave catchers? Or does it only mean that where there's a direct contradiction, the federal law trumps? And the answer is federal power is exclusive. States are not permitted to pass any laws on this subject or to apply their ordinary criminal laws to this particular subject. Why? Well, again, originalism. That was the only understanding that the southern states would have accepted in 1787. Therefore, it must be the understanding that should be enforced by the courts today. It is scarcely conceivable that the slaveholding states would have been satisfied with leaving to the legislation of the non-slaveholding states a power of regulation in the absence of that of Congress, which would or might practically amount to a power to destroy the rights of the owner. Right? Between 1787 and 1793, the Fugitive Slave Act has not yet been passed. It is impossible to imagine that the slaveholding states thought that during that period, in the absence of federal law, free states had a free hand to pass laws that would effectively make free any fugitive slave that got into their territory. Can't believe that. Therefore, that's not the case. Construe the right of legislation as exclusive in Congress, right? Say that this is on the side of the Venn diagram, it's an exclusive federal power that states were always precluded from regulating, and every evil, every danger vanishes. But upon the other supposition, the moment he passes the state line, he becomes amenable to the laws of another sovereignty, whose regulations may greatly embarrass or delay the exercise of the rights and even be repugnant to those of the states where he first arrested the fugitive. Right? So would not have they would not have agreed to. It's sort of going back to that language in Calder about the social compact. There are certain powers that it would be absurd to suggest have been given to government under the social compact, and therefore we will not assume that this has been done. This is now a less philosophical, more historical version. It is the case that as of 1787, some of the participants in the adoption of the Constitution would not have agreed to X. Therefore, the Constitution cannot mean X. And that's it. Right, so notice, this is not the Commerce Clause. This is the Fugitive Slave Act and the Fugitive Slave Clause. But notice the Fugitive Slave Clause has dormant effect. That is, according to this logic, the Fugitive Slave Clause preempts state legislation even in the absence of any federal legislation. Right? It moves the topic into the exclusively federal area. Well, the same kind of question arises under the Commerce Clause, and we'll turn to that next. So, you remember the Venn diagram? It's pretty simplistic. It's a shaded area in the middle. So when we're talking about the Commerce Clause, right, one question is a power given exclusively to the federal government? And the Supreme Court says under the Fugitive Slave Clause, that's the case. A different question arises under the Commerce Clause. Under the Commerce Clause, when we talk about preemption, we're talking about areas in which there could be federal and state authority. It's at least not clear. And what happens? And the answer is going to be, I don't want this to be mysterious to you, as we get up to the 20th century, the answer is going to be, in some cases, we will treat the grant of federal power as exclusive. So if we say Congress has a power over X, and we say that that grant of power is exclusive, that means it's not in the shaded area, it's in this part of the Venn diagram, it's an exclusive federal power. In some instances, we're going to say the federal government and the states have concurrent authority. They can both regulate on the subject, but if there's a direct conflict between a federal law and a state law, the federal law trumps. No mystery there. The difficult and interesting cases are going to be what happens in that shaded area where laws have not yet been passed. Well, actually, all of these become difficult and interesting depending how they're framed. But the third question is, what happens in that shaded area of potential concurrent authority where there's not a direct conflict between a federal law and a state law, just as we just saw with the Fugitive Slave Act? Okay? So the dormant Commerce Clause is the idea that states may not regulate in certain areas just because those areas are open to federal regulation, even if no federal regulation has been enacted. The second, that's one concept we're going to need to have this. Is that fairly clear? Right? You notice, you can this can come up, this can appear in its logic either as saying, oh, this power is on the exclusively federal side of the Venn diagram, or it can appear in the logic of saying, well, it's in the shaded area, but for various XYZ reasons, the states may not regulate here. Let me give you an example. This is an idea that doesn't get developed till the 20th century. But there's something called occupation of the field. I think it's good to have these concepts in your head as you see how they develop. It's easier than being surprised by them later. So in the 20th century, we're going to get the idea of occupation of the field. If Congress has passed laws in an area, regulation of the airwaves, let's say, FCC, right? Regulation of television and radio and so on. The internet is complicated. For that matter, cable television is complicated. Regulation of the airwaves. If Congress has passed laws in an area, and the court finds that Congress intended to cover that area completely, they intended to occupy that field, or if in practice the federal laws occupy the field, it's a complete scheme of regulation, then states are not allowed to make regulations in that area, even if there's no actual conflict between a state regulation and a federal regulation. So occupation of the field is a form of preemption that occurs in that shaded area. If Congress had not passed such an extensive scope scheme of regulation, states would be free to regulate in that area. But because Congress has occupied the field, states are precluded by preemption. Get it? Right, so there are several different ways this can play out, depending on the nature of the question. Wilson versus Blackbird Creek Marsh, for example, in 1829, is one of the very first cases to explore these questions. It's not a very momentous case on its facts. A sailboat broke a dam. The dam owner is sued for damages. The sailboat argued that the dam was illegal in the first place because building the dam had been authorized under Delaware state law, but the sailboat, this is a sailboat owner, for heaven's sake, who ran into a dam. This is how these things come up. The sailboat owner argued that because Congress, under the Commerce Clause, has authority to regulate navigable waters, that preempts any state law in that area. Right? The phrase is anachronistic, it hasn't been invented yet, but think of occupation of the field. Except that in this case it's I'm sorry, that's not true, I'm sorry. The claim is that the Constitution vests exclusive authority in the federal government over this area. It's on that part of the Venn diagram. And therefore Delaware was acting beyond its authority when it authorized the construction of this dam. The dam is illegal, no damages need to be paid. That's the issue. Marshall writes the opinion, and he says, and he starts by observing that states have police powers. We've talked about police powers, right? States generally have the power to make regulations for the health, safety, welfare, and morals of its people. And that includes making regulation to enhance the value of property. The value of property on its banks must be enhanced by excluding the water from the marsh, and the health of the inhabitants probably improved. That is, the dam was built to drain a marsh to do various good things. Measures calculated to produce these objects, provided they do not come into collision with the powers of the general government, are undoubtedly within those which are reserved to the states. Here, in other words, we have an area of concurrent authority. If there is no federal law, this is what Marshall is saying, if there's no federal law that's being interfered with by the exercise of the state police powers, then the states are perfectly free to exercise their police powers. If Congress had passed any act which bore upon the case, any act in execution of the power to regulate commerce, the object of which was to control state legislation over these small navigable creeks, we should feel not much difficulty in saying that a state law would be void. Coming into conflict with it would be void, right? If there were a federal law that conflicted with a state law, easy call. Federal law trumps. But Congress has passed no such act. The repugnancy of the law of Delaware of the Constitution is placed entirely on its repugnancy to the power to regulate commerce. The sailboat owner's claim is because the federal government has the power to regulate interstate commerce, that means nobody else does. It's an exclusive grant of power. And Marshall's saying, no, it's not. There's that shaded area in the Venn diagram where the powers of the federal government and the powers of the state governments overlap. We do not think the act can be considered as repugnant to the power to regulate commerce in its dormant state. And the phrase dormant commerce clause comes from this opinion by Marshall. City of New York versus Miln. What other state police powers are there? And how does thinking about these questions help us isolate not only what powers are exclusive to the federal government, but what powers are exclusive to the states? Right? This question of preemption becomes a matter of defining the boundaries of federalism. Because you're going to identify, in that same Venn diagram, certain powers are exclusive to the states. The federal government can't go there. Certain powers are exclusive to the federal government, and some are in the middle. And by the time you've finished filling in all these categories, you have laid out the details of a system of federalism. So the city of New York versus Miln involved immigration control. New York had an 1824 law, I put the quotation here in the notes, that every commander of a ship landing in New York Harbor had to file a written report with the harbor master, listing the occupations, a report in writing of the name, place of birth, last legal settlement, age, and occupation of every person who shall have been brought as a passenger in such ship or vessel. What are they trying to avoid? Poor people. They don't want ships unloading poor people into the city of New York. And so if the harbor master says, this person has no occupation listed, they won't be allowed to enter. Question. The United States federal government has authority over ports of entry, navigable waters, international affairs. Does that exclude New York's authority to have a regulation of its own harbor to prevent poor foreigners from entering into the country? Well, into both the country and the state. And the answer is no, it does not. That is, New York retains the police power to do this. It is not preempted by the fact that the federal government has concurrent authority over questions of immigration. So here's a case of genuine concurrent authority. Both the federal and the state governments may regulate who can get off a ship in New York Harbor, as long as the laws don't directly conflict. Justice Barbour writes the opinion. So New York's argument. On the part of the plaintiff, state of New York, it is argued that an affirmative grant of power previously existing to the states, to Congress, you take a power, the delegation of the national government of a power, is not exclusive except, one, where it is so expressly declared in terms by the clause giving that power. So if the Constitution explicitly says this is a sole power of the federal government. Two, where a similar power is prohibited to the states, Article 1, Section 10. Is there a place in Article 1, Section 10 that says states can't do this? Then they can't do this. Or three, where the power in the states would be repugnant to and incompatible with a similar power in Congress. Right? So if, again, there's that dormant commerce clause idea. What if even in the absence of a federal enactment, giving states the power to regulate in this area would interfere, would be repugnant to, contrary to the idea of federal authority over this area? In this case, however, says New York State, none of those apply. We shall not enter into any examination of the question whether the power to regulate commerce be or be not exclusive of the states. We're not going to answer that question. Because it's unnecessary. In other words, we are of the opinion the act is not a regulation of commerce, but of police. This is not a matter of, there's no issue here of whether this conflicts with the federal regulation of commerce. This is the exercise of police powers, and police powers remain with the states. The federal government has no general police powers. It only has the authority to regulate, relevant to this discussion, it only has the authority to regulate commerce. The entire federal criminal code is based on the Commerce Clause. The reason there's a category of federal crimes is that it's justified as the regulation of interstate commerce. There is no federal power to punish crimes per se, as there is for states. Think about that in the context of Prigg that we just looked at. We are thus being considered it was passed in the exercise of power which rightfully belongs to the states. And he goes to Federalist 54 to understand the original understanding. It says the powers reserved to the several states all extend to all the objects which in the ordinary course of affairs concern the lives, liberties, and properties of the people. And he points to Gibbons versus Ogden, where Marshall, in order to identify an example of what's a classic state authority, talked about quarantines and health measures. Right? Keeping out sick people from entering your ports. In speaking of the inspection laws of the state, say they form a portion of that immense mass of legislation which embraces everything within the territory of a state not surrendered to the general government. We hold the state has the same undeniable and unlimited jurisdiction over all persons and things within its territorial limits as any foreign nation, where that jurisdiction is not surrendered to or restrained by the Constitution. So apply the test here. How do we say that this law is not a regulation of commerce? It's an exercise of police powers? Oh, it's analogous to a criminal law, says Barbour. There can be no mode in which the power to regulate internal police can be more appropriately exercised. New York is perhaps more than any other city in the Union exposed to the evil of thousands of foreign immigrants arriving there and the consequent danger of her citizens being subjected to a heavy charge in the maintenance of those who are poor. It is the duty of the state to protect its citizens from this evil. If you let in lots of poor people, their presence puts a strain on the Treasury. It is the legitimate interests of the state of New York to protect it. This is exactly the argument we're having now about immigration on the Mexican, well, one of them, on the Mexican borders. This is one of the arguments that has been asserted by, for example, the state of Texas as the basis for its standing. Why is Texas able to sue the federal government to insist that it enforce immigration laws? Answer, because if lots of poor people enter the United States, that will put a strain on the Treasury. The argument goes back to Miln versus New York. Keeping out poor people is a legitimate state function to protect the Treasury and therefore remains a power of the states. It's just like inspection and quarantine laws. The power to pass these inspection laws is itself a branch of the general power to regulate internal police. Again, the power to pass quarantine laws operates on the ship which arrives, the goods which it brings, all powers in it, whether the officers and crew or the passengers. The officers and crew are not agents of navigation. The ship is an instrument of it, and the cargo on board is the subject of commerce. Yet, it is not only admitted this power remains with the states, but the laws of the United States expressly sanction the quarantines and other measures. Right? In other words, look, if the Commerce Clause meant that you can't regulate what gets unloaded from ships in your harbor, then you couldn't have state quarantine laws. I mean, that's commerce, isn't it? If the dormant Commerce Clause meant that even in the absence of contrary federal regulations, states are precluded from having rules about what gets unloaded by ships in their harbor, then quarantine laws would have to fall to this assertion of the dormant Commerce Clause. But in Gibbons, Marshall said that's not true. We have federal laws that say that's not true. Everybody agrees that's not true. So since we know states can have health and safety laws and quarantine people getting off of ships, coming, for example, from places where there's yellow fever or plague or some other disease, right? If you were allowed to do that for a health reason, you equally have to be able to do the same thing to avoid a possibility of an influx of poor people. We think it is as competent and as necessary for a state to provide precautionary measures against the moral pestilence of paupers, vagabonds, and possibly convicts. They might not be sending us their best people. They might be sending us criminals. As it is to guard against the physical pestilence which may arise from the unsound and infectious articles imported, or from a ship the crew of which may be laboring under an infectious disease. So the general state authority, which is unquestioned, to regulate in order to preserve health and safety, extends to regulate to protect the state and its residents against other possible dangers, and that's not preempted by the fact that the federal government has authority over international as well as interstate commerce. Unless, we're very, very careful here, unless the federal government has passed a law. Now, we're talking about the dormant Commerce Clause here. In the absence of federal legislation, do states have this authority? If the federal government passes a law which directly contradicts a state law, so if there were a federal law that says no one may be prohibited from disembarking from a ship landing in a port on the basis that they have no money, right? If that were a federal law, then the state law would give way. So you've got to be very careful to distinguish between the operation of the dormant Commerce Clause, the limitation on state authorities that exists even in the absence of federal legislation, and the question of direct preemption that occurs when there's a federal law that contradicts a state law outright by its terms. I realize I'm being repetitive and going very slowly, but this can be somewhat confusing as you get to particular cases. Cooley versus Board of Wardens, 1852. This is the dormant Commerce Clause leading to implied preemption. Okay, let me not be coy. This is the case that introduces the idea that there are some subject matters that by their nature can only be governed by the federal government, because it's just inappropriate to allow these subject matters to be governed by state law because of the Commerce Clause. So in 1789, a federal law is adopted that makes regulations about the use of pilots. You don't know what a pilot is in this context? A ship crosses the Atlantic Ocean, it gets to New York Harbor. The master of that ship is not familiar with the specifics of the harbor. Where are stobs, things sticking up? Where are sandbars? Where are shallows? So a pilot will take over. In the modern era tugboats, it's a separate boat sometimes, will take over and guide it into the harbor for that last bit. The federal government passes some laws about this, about the use of pilots in international ports and so on. In 1803, Pennsylvania passes a law that says you have to use a local pilot. Now, the Pennsylvania law does not contradict the federal law. Nothing in the federal law says you may use a non-local pilot. There's no direct contradiction here. The question is this a dormant Commerce Clause area? Curtis writes for the majority, and he says the answer to that question depends on the nature of the activity being regulated. If they are excluded, it must be because the nature of the power granted to Congress requires that a similar authority should not exist in the states. Right? Dormant Commerce Clause. Now, the power to regulate commerce embraces a vast field, containing not only many, but exceedingly various subjects, quite unlike in their nature. So even within the Commerce Clause, some activities that are regulable by Congress are different from others. Some imperatively demanding a single uniform rule, operating equally on the commerce of the United States in every port. Some as imperatively demanding that diversity which alone can meet the local necessities of navigation. So Curtis is going to argue that there are some areas in which the fact that the federal government has authority under the Commerce Clause does preclude state regulation because by the nature of the activity in question, there has to be a uniform rule. But this is not that case, he says. This is a case about the pilots who guide ships into the harbors, and that needs local knowledge of local conditions. So it's a topic that's perfectly suited to be regulated by local laws rather than a uniform national regulation. Whatever subjects to this power are in their nature national, or admit of only one uniform system or plan of regulation, may justly be said to be of such a nature as to require exclusive legislation by Congress. This cannot be affirmed of laws for the regulation of pilots and pilotage, which is plain. And that's the end. McLean dissents. McLean argues that it's not up to judges to determine when a grant of power to Congress is exclusive and when it isn't. It's up to Congress. He's arguing that this is essentially judicial activism, a usurpation by federal courts of the authority of Congress to determine what is necessary and proper for the exercise of its authority under the Commerce Clause. The power is recognized in the states because the subject is more appropriate for state than federal action. Consequently, it must be presumed that the Constitution cannot have intended to inhibit state action. This is not a rule by which the Constitution is to be construed. Where did courts get the authority to decide what economic activities by their nature require uniform national rule and which ones do not? How is that a question arising under the Constitution? It ought to be, says McLean, left to Congress to work out. And then Congress can pass whatever laws it wants, and whatever laws Congress has passed, preempt contrary state laws. Simple. Peter Daniel concurs. He makes the opposite argument. He argues that regulation of this area is exclusively a state power, that it doesn't fall within the federal government's power under the Commerce Clause at all. The power delegated to Congress does not necessarily, nor even naturally, extend to the means of precaution and safety adopted within the waters or limits of the states. These last subjects are essentially local. So Daniel's argument is reverse preemption. Yes, the federal government has authority over commerce, international commerce, interstate commerce, but there's an implicit reservation to the states. There's an implicit limitation on Congress's power under the Commerce Clause because these matters are essentially local. So you have, one, an argument, if matters are essentially national, then they're subject to a uniform rule, and only the federal government may regulate it. You have well, it's a concurring opinion because he agrees in the outcome, but he has a very different reasoning. You have Daniel arguing on the other hand, no. Certain powers are exclusively state because they are by their nature local matters of concern and therefore weren't within the Commerce Clause in the first place. And you have McLean in the middle saying, where do either of you get the authority to make either of these determinations? Whether something is inherently local or inherently national, that's not a judicial function. Here's Daniel. These last subjects are essentially local. They must depend upon local necessities. It is admitted on all hands they cannot be uniform or even general, but must vary so as to meet the purposes to be accomplished. All right. Well, we're going to end way early today. Okay. I hope none of you will complain bitterly that you're not getting your money's worth. I can keep talking if you want. Just ramble on for an extra 45 minutes. Nah, let's not. Final question about federalism and preemption, nullification. So we've seen this before. I think I also mentioned this last time. In 1832, the question of state authority to nullify federal laws rises again. This time, it's not state courts, as in Martin versus Hunter-Lessee, or Ware versus Hilton for that matter. This time, it's state legislatures. South Carolina asserts that since it's a member of the compact, the compact theory, states bound by a treaty, since it is as a state, a member of the national compact, it has the authority to interpret the meaning of that compact for itself, as nations signatory to treaties have the authority to do. And therefore, that means that the legislature of South Carolina can overrule a federal law or a decision of a federal court on questions of the Constitution. The nullification of ordinance of 1832, that the laws for the imposing of duties and imposts on the importation of foreign commodities are unauthorized by the Constitution. Remember we talked about this, and this is the force law that Calhoun was very excited about? It shall not be lawful for any of the constituted authorities, whether of this state or the United States, to enforce the payment of duties imposed by said acts within limits of this state. And we have this happening again today. States are passing laws saying things like it shall not be lawful for any state official to enforce a federal gun law, or it shall not be lawful for any state official to participate in the enforcement of federal immigration laws. There's a whole slew of attempts in various states from different political directions in which legislatures, state legislatures, are passing laws making it a crime to participate in the enforcement of federal law. Madison, who is still running around at this time, is virulently opposed to this whole theory. So that moment in the Virginia resolution against the Sedition Act, when Madison spoke the language of compact, it's a unique moment. Neither before nor afterwards does he talk that way. In response to South Carolina's assertion, he's quite vehement that states have no power of nullification because they have no independent sovereignty. Here's Calhoun. Sorry, we read part of the Calhoun speech last time. Remember the affirmative defense of slavery, his 1837 speech. In the book, you have an excerpt from his address on nullification in 1831. It just lays out the case that I've just made. That it flows from the compact theory that legislatures of states have independent authority to determine the validity of federal law and to make it a crime, to preclude state officials or anyone else within their state from carrying out the enforcement of federal law. Question, could they arrest a federal official? Answer, no, because of McCulloch. But is that a tenable distinction? And again, this is going on right now in multiple states on multiple issues. The idea of nullification has been revived just in the last 10 years. We hadn't seen it for a very long time. Thus reminding us of the truth of Faulkner's famous dictum, in America, the past not only isn't dead, it isn't even past. And through an error of planning on my part, that's all I have for today. Sorry about that. Sometimes I think I mentioned I broke all these lectures into mini lectures last year to do them online, and then I reassembled them, and the process of reassembly has not been perfect. Enjoy your free time. How's that?